Hot news: the Supreme Court's peyote decision limited freedom of religion. Is it in trouble? A landmark Supreme Court decision cutting back on religious freedom under the First Amendment may be in trouble. In 1990, the Supreme Court ruled against two Oregon drug counselors who had been denied unemployment compensation after they were fired for ingesting peyote, an illegal substance, during Native American religious rites. Unlike other states, writing for the court, the late Justice Antonin Scalia held that the First Amendment's protection of the free exercise of religion wasn't violated when a state passed a neutral, generally applicable law that just happened to make it harder for some people to practice their religion. The so-called peyote case led to a bipartisan backlash in Congress, and in 1993 President Clinton signed that measure allowed, eventually, the bipartisan consensus in favor of RFRA. A turning point. In her dissent, Justice Ruth Bader Ginsburg warned that RFRA was being used to harm third parties such as the female employees of companies whose owners objected to birth control. Disaffection with, but the Supreme Court could render such action futile. That scenario was raised Tuesday when Justice Samuel A. Alito Jr. issued a statement in connection with the Supreme Court's to hear the case of a Bremerton, Washington, high school football coach who was fired as he alleged because he wouldn't stop praying on the field. Joined by Justices Clarence Thomas, Neil M. Gorsuch and Brett M. Kavanaugh, Alito agreed that the court shouldn't take the case because of important unresolved factual questions, notably, whether the coach had been fired for praying or for neglecting his duties. Alito went on to say that which ruled against the coach, had taken a troublingly narrow view of teachers' free speech rights. But that wasn't his. Towards the end of his statement, Alito suggested that Kennedy had relied primarily on a free speech claim rather than a freedom of religion claim because of certain decisions of this court. One of those decisions, but he noted that in this case the court wasn't being asked to reconsider that decision or another ruling, rooted in the federal civil rights law, that also harmed the coach's prospects. This line near the end of Alito's statement was the judicial equivalent of the bad journalist's practice of burying the lead. If that happened, it wouldn't matter if Congress repealed RFRA. Congress can 20 years ago, a rollback of the peyote decision might have been greeted with bipartisan acclaim. Today it's a process.
Raindrop, drop top, top smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up.